Just by way of a disclaimer, I had wanted a platform to put my papers on, but if I stand behind there, you won't see me. So I'm clumsily holding my papers, so you'll just have to excuse me. Hopefully you'll all be making notes anyway, so you won't be looking at me. I don't need to tell you, you all in the field, our labour legislation, since the rebirth of our country, has played the role of remedying the past exploitation of the workforce, remedying the disparity, etc., etc. Idealistic, yes. Necessary, yes. Complex and fraught with difficulties, I think you know the answer to that. But that is why it's dynamic and vibrant, and because of that we should be proud of it. One such category of vulnerable employees that the law seeks to protect is employees that fall under the category of temporary employment services. This is a long-standing feature of South Africa's labour market, popular with businesses because it provides flexibility in the procurement of labour. I'm sure you're aware of the issues that make this category of employees vulnerable, such as abuse and the dilution of collective bargaining rights. This is why the unions were so strongly opposed to the retention of labour broking. They see it as akin to modern-day slavery. There's no question that TES, Temporary Employment Services, benefits businesses. This, obviously, as we know, results in employment for a larger portion of the workforce, which in turn is good for the economy. As we all know, this comes full circle. What is good for the economy is good for the workforce. Recognizing this fact, the amendments therefore sought to balance the competing interests of business and labour. With the original legal framework, Section 198 of the LRA, employment rights and claims are generally exercised by employees against the labour broker as the employer. And the client has not traditionally played a role in this relationship. The client had the contractual relationship with the labour broker. There was very limited joint and several liability on the part of the client. Section 198 continues to apply with the retention of the general provisions that the labour broker, as opposed to the client, is the employer and pays the employee to work for the client. The broker and client are joint and severally liable for specified basic conditions contraventions, and there's no LRA joint and several liability. This section has been amended to include provisions that make it impossible for employers to use TES as a loophole to divest themselves of employee-related risks and liabilities. In terms of the amendments, an employee may institute proceedings against either the labour broker or the client, or both, where joint and severally liable, and may enforce any order or award made against the broker or client or against either of them. A labour inspector may secure or enforce compliance against the broker or the client as if the client were the employer. The broker may not employ any employee on terms and conditions not permitted by the LRA, sectoral determination, or collective agreement. It is the industry in which the client is engaged, not the broker, that determines what bargaining council or sectoral determination applies. So, therefore, it cannot be used as a way for an employer to try and get around the laws associated with bargaining councils and collective agreements, which in the past is what employers have tried to do. The labour court or an arbitrator can rule on whether a labour broking agreement complies with the LRA and make an appropriate award. A broker must be registered to conduct a business, but lack of registration is not a defence to any claim. A labour broker employee must be given written particulars of employment. The new section 198A introduces key additional protections
for those employees earning below the basic conditions threshold. And this is where things get tricky. Significant consequences attached to the length of a temporary worker's assignment from the labor broker to the client. Only where an employee is performing temporary services is the broker the employer to the exclusion of the client. Otherwise, the client will be deemed to be the employer of the temporary employee, so liable in respect of unfair dismissal, etc. This is what is going to open the floodgates to all sorts of claims coming before the CCMA and the Bargaining Council, that deeming provision. Temporary services means work for a client by an employee for a period not exceeding 3 months. This is as opposed to 6 months, which was originally canvassed. As a substitute for an employee of the client who is temporarily absent, so for example, due to maternity leave, in a category of work, and for a period of time which is determined to be temporary services in a bargaining council collective agreement, sectoral determination, or notice published by the minister. That, because it's so vague, is also likely to cause issues and will be subject to, or have to be subject to, interpretation by the CCMA or bargaining councils. That is also going to, I would imagine, open the floodgates to lots of cases before the CCMA. The termination by a labor broker of an employee's assignment with a client for the purposes of avoiding Section 198A, the consequence would be the consequence is that this would be seen to be a dismissal. Where an employee is deemed to be an employee of the client, they will be entitled to terms and conditions that are on the whole no less favorable by comparison to the client's employees performing the same work, unless there's a justifiable reason. A justifiable reason could include experience, seniority, length of service, merit, the quality or the quantity of the work performed, or any other criteria of a similar nature which is not unfairly discriminatory. This again will have to be tested in time to come. All the issues that might or might not arise as a result of this, we will only really know probably within several months to a year of this legislation being gazetted. At this point, it's impossible to predict what kinds of cases will go before the CCMA or the Bargaining Council, but the chances are, because the Act doesn't clearly define certain things, the chances are that we probably will see a flood of cases, especially relating to the interpretation and application of this new section. Interestingly, and for those of you who are involved with smaller businesses that have been operating for less than 2 years with under 50 employees, and businesses with fewer than 10 employees, regardless of how long they've been operational, have been exempted from these new provisions. The Chamber of Commerce feels that while it's something, it's not enough, but it is something at least. And then, as mentioned previously, there's a 3-month grace period that would relate to employees currently employed until these provisions would kick in. What are the implications of this? Firstly, there needs to be quite significant clarity on what some of these new provisions actually mean in practice. And the CCMA and the Bargaining Council will likely play an active role in that clarity, especially in respect of what temporary services actually means. That has been left quite open. Likely, obviously, this will probably put businesses and employers off from dealing with labor brokers in the future. There'll be reduced incentive, and there'll be more incentive to employ people on a permanent basis, which might seem like a positive thing and what the legislation is trying to achieve. However, in reality, it's likely to be a very different story. And I found some interesting statistics which I'll read to you in a minute, but the chances are that it will have the opposite effect. Labor brokers employ a large number of people. Temporary employees make up a large number of the workforce. With these new provisions, what's likely to happen is that employers are just going to employ fewer people, and it's going to result in greater unemployment. The loophole of setting up a labor broker as a front to enable a business to transfer its workforce to the labor broker in order to avoid risk and liabilities, this has been blocked. We, in practice, have dealt with this in the past, employers trying to limit the risks and liabilities involved with employing people in this country. What will happen now is that we will just have to, I hope it doesn't sound like there are any trade unions here, we'll just have to get more creative in finding ways to minimize the risks and liabilities for our employer clients. And that's what will happen across the board. Contracts will have to be very, very carefully drafted in order to mitigate risk. Brokers and clients will have to work quite closely together to ensure compliance and fair treatment of employees. It may be necessary for clients to insist that disciplinary decisions taken by the labor broker be done in consultation with the client. There will have to be more of a collaborative process to ensure that some of the pitfalls here are avoided. As I said before, unfortunately, my interpretation of all of this is that what we are likely to see is our unemployment statistics are only going to get worse. And in relation to that, just of interest, I came across an article where it says that over the past decade, the international trend has been to limit or remove restrictive labor laws to ensure global competitiveness. Obviously, that's what makes sense. The World Economic Forum suggests that South Africa has arguably, and there's no surprise here, the most restrictive labor laws in the world. And as we know, that's bad for foreign investment and bad for employment. The statistics show that despite this impending legislation, the only growth in South Africa's employment level is because of an increase in temporary or short-term contracts. In fact, permanent employment is in outright decline. So the statistics support the unfortunate probable outcome of this new legislation. I'm not saying that it wasn't necessary to block some of the loopholes that employers were finding, which resulted in unfairness to employees. There's no question that labor broking can result in abuse to employees. However, has the legislation gone too far? Is it too restrictive? That will, in time, reveal itself. Of further interest, Lawrence Diamond, the CEO of Workforce Group, said, "The real challenge is not around our sector because we are the engine of job creation, skills development, and increased business competitiveness. It is for companies to partner with a viable TES provider, one that can enable swift adaptation to change with new and innovative solutions to labor market challenges. In essence, a valued and crucial partner for businesses and employees." Now, obviously he's going to say that. Is that true? It remains to be seen. Certainly, if done responsibly and carefully, one could mitigate some of the pitfalls involved. But this is someone who has a vested interest, so it's perhaps somewhat of a biased view. I'm of the view that some of this legislation will be further clarified once we have some case law precedent. The cases in the past, I mean, if we have some time and if you're interested, there's some cases here that you might find interesting or you might be aware of. Labuskachny versus WP Construction, a 1997 case heard by the CCMA. The employee was hired by WP Construction, a labor broker, and assigned to work at Central West, a client of the labor broker. The foreman of Central West caught Labuskachny sleeping and terminated his assignment. He referred an unfair dismissal dispute to the CCMA. The CCMA regarded WP Construction, the labor broker, to be the employer in terms of the original Section 198. The broker claimed that Labuskachny was not its employee at all because the broker had hired him as an independent contractor. Despite these defenses, the CCMA arbitrator found that while the broker claimed that Labuskachny was an independent contractor, the circumstances under which he worked showed him to be an employee of the broker. And the labor broker, who had in fact not even been involved in the dismissal, was therefore forced to pay the employee compensation. Now, this would have been different now according to these new provisions, but that was the practical reality at the time. In terms of the new provisions, that deeming provision, that is going to change things significantly, and that's what clients of labor brokers are going to have to be very much